Please, Your Lordship. Lordship, I beg to mention item number 9 of daily list. Lordship, the matter may be taken after 4 days, Lordship.
You are for the petitioner.
Lordship.
On the prayer of learned counsel for the petitioner, this matter stands passed over for the day. List again in the next week.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 7 of the daily list, lordship.
Mhm.
Lordship, sometime may be granted to file affidavit, lordship.
You are for the
Petitioner, lordship.
On the prayer of learned counsel for the petitioner, this matter stands adjourned for 2 weeks so as to enable
Yes,
her to
Lordship.
file an additional.
Deeply honored.
Praise the Lord. I beg to mention item 34, my lord. I filed an IA in this case. So kindly this matter may be taken up on Friday next.
Friday, we are not coming to
My
next week. Next
Anyway,
week.
it will come up with the IA automatically.
Item number?
34, my lord.
Item 34. You want this Friday or next Friday? This Friday is a holiday.
Next Friday, my lord.
Next Friday. Mr. N. Anand, the counsel for the petitioner submits that an interlocutory application has been filed in this contempt case, which is not listed today. In view of the above, registry list this case along with the IA. You want a firm date?
This Friday.
On 5th of April? 5th of April?
My lord.
5th of
Highly advised, ma'am.
Yes.
Daily list promotion item 1.
May it
Yes.
please, Your Lordship. Lordship. Matter timing, Lordship. I
Sorry?
see you receive.
You want it to be passed over?
No, timing.
Password for the time.
What is this case about, Miss?
My lord, I have not seen it. We have received certain instruction, my lord.
Hmm. So why don't we issue notice?
Oh, yes, my lord. Notice is not issued. This for instruction. We have received some instruction. Better, my lord, we should file an affidavit, my lord.
All right, then we'll issue notice.
Yes, notice
6
may
days.
issue, my lord.
All right. Your name, please. Your name, please.
Ar Khatun. Ar Khatun.
Well, so learned counsel. There he is, Mr. M. Mondal, learned counsel appearing for the petitioner. Mr. Mondal, they have received instruction. They want to file affidavit. We'll issue notice at this time. And counsel appearing for the writ petitioner in both these cases. I also heard Mr. T. Stupiel and an additional senior government advocate appearing for the official respondents, right?
Yes, ma'am. All the respond.
Peruse the averments made in the writ petition. The controversy raised in this proceeding pertains to the proposed shifting of an Anganwadi center from Chaudhuri Char to shifting from Chaudhuri Char to
Shifting to Chaudhary Chowk to Middle Andamari. From Andamari, Anganwadi Center.
Andamari Anganwadi Andamari.
Yes.
Mr. T.C. Chutial and a government advocate submits that he has received instructions and therefore be granted some time to file affidavit. NOM 4 weeks since the respondents are already represented, no formal notice, extra copy. List these cases again after 4 weeks. Yes.
Item 3.
1 and 2 do take, you know?
1 and 2.
Publish.
Yes, who is appearing in this case? Anybody is appearing? Item 3? For the time being, we'll call up again. Time being.
Item 4.
Order is page 11, my lord. Order is page 11, my lord. Operative portion page 11, my lord. And operative portion, my lord, page 14.
All right, you take down, heard Mr. H.R. Amin, learned counsel for the petitioner. Whereas the statements made in the contempt petition alleging willful disobedience of the order dated 24/5/2023 passed by this court in WPC number 2911/2024. This petition has been filed. Issue notice returnable in 8 weeks. Petitioner to take steps. Issue notice upon respond numbers 2 and 3 returnable. No, it is only appoint. Why have you included the staff selection commission? Respond number 3 returnable in 8 weeks. Petitioner to take steps by registered post with AD. Question of issuance of notice upon the respond numbers 1 and 2 will be considered at an appropriate stage as and when the occasion arises.
Obliged, my lord.
Item 5.
May I please your lordship?
Yes.
Non-compliance of order dated 13/3/2023. Kindly see page 117, operative part of the judgment. The matter was remanded back to SLC for fresh consideration, but it is still not placed before the SLC.
Right. I heard Miss, your name, please.
K. Burman.
K. Burman, I counsel for the petitioner. Here is the amendments made in the contempt petition. This petition has been filed alleging willful disobedience of the order dated 13/3/2023 passed by this court in WPC number 6930/2022. Issue notice upon the respondents returnable in 8 weeks. Petitioner to take steps for service of notice upon the respondents by registered post.
Obliged.
Item 6.
Yes, my lord. Good morning. My petitioner, Dr. Dinanath Kolita, is again and again deprived.
Your
From
client
his
is
post-
retired.
Ah.
Your client is retired from service.
No, my lord. See, he is in extension. He is in extension for 5 years.
Extension is what?
His post is able now. There's a he is able the post Kahikusi, head of the scientist and principal heads and head of the Krishi Vigyan Kendra Kamrup, Assam Agricultural University.
So what is your grievance?
Kahikusi.
What is your-
He has appointed chief scientist horticultural research center, Assam Agricultural University, Kamrup, from University, Agricultural University, my lord, at the time of 2019, but some showing some region previous from
Oh, you are
previous-
appearing, Mr. Kotaki.
Yes, my university, my lord. We have received instructor, my lord. Actually, he belonged to a different set of cadre, my lord.
You file your affidavit.
Yes, yes. And already one person is already in charge appointed, my lord.
Right. Will issue notice.
Yes.
Yes, my lord.
You take them here, Mrs. M. Burman, I can't for the writ petitioner. Whereas the amendments made in the writ petition, the controversy raised in this petition pertains to the claim of the petitioner to be appointed as chief scientist in the
HR, horticulture research station, Kahikusi.
Huh?
Horticultural research station, Kahikusi.
Horticulture Research Institution,
Kahikuchi.
Kahikuchi. Mr. P. Kotaki, learned counsel appearing for the Assam Agriculture University, prays for some time to obtain instruction in file affidavit. Issue notice of motion returnable in 6 weeks. This Mr. Kotaki has appeared and accepted notice on behalf of respondent numbers 1 to 5. No formal notice is required to be sent to the said respondents. Extra copies of the writ petition, requisited numbers, be furnished to the learned standing council. Petitioner takes steps for service of notice upon respondent number 6 by registered post with AD.
Yes, my lord. Apply.
Item 8.
May I please? But this matter regarding compassionate appointment.
So we'll issue notice, that's all. Notice. But Mr. Learned Counsel for the petitioner, the matter pertains to claim of the petitioner for appointment on compassionate ground. I peruse the amendments made in the petition. Stop. Mr. Chakravarti, learned government advocate, Assam prays for some time to obtain instruction in the matter. NOM 8 weeks since Mr. Chakravarti has appeared and accepted notice on behalf of respondent numbers
3 and 4 lots.
3 and 4 and Mr. I. Botakur, learned SC PhD for respondent numbers 1, 2 and 5. Service of notice is deemed to be complete in this case. Extra copy of the writ petition be furnished to the learned department counsel, requisite in numbers, so as to enable them to obtain instruction.
Okay. Keep looking.
Item 10. Item 10.
Call after some time.
Item 11.
May I tell Lordship?
Yes.
Lordship, in this case, Lordship petitioner is Lordship Community Health Officer, Lordship. And he was arrested in a case, Lordship. Thereafter, Lordship, he was released on bail. But after releasing Lordship, he approached to the authority, but the authority was not allowing to Lordship resuming duty. He has not been issued any suspension order, Lordship, till date, Lordship. And nothing,
Which is the department?
Lordship, it is and he is under National Health Mission, Lordship. NRHM. On last 2 occasions, Lordship, instruction was sought, Lordship.
Who is the standing counsel? Where is Miss A. Bora? SC NHM, Miss Bora, can you
Lord.
inform?
Item 12. Item 13.
One time being.
Make resolution.
Yes.
My lord, this matter relates to my lord selection to the post of peon in the office of the district and session judge South Salmar Mankachar, my lord. So lordship will kindly see page number 18, my lord.
Hmm.
By this advertisement, my lord, where vacancies for the post of peon was advertised, my lord. 6 were reserved and 6 were unreserved, my lord. The petitioner applied and in the final selection list, he was placed at number 2 in the waiting list, my lord. My lord will kindly see page number 27.
So there is one above you.
Yes,
So even if it is to be 6 instead of 5,
yes,
you don't get it.
yes. But the thing is that, my
So
lord,
if it is yes, then
my lord,
the answer is no here.
the thing is that, my lord, they filled up only 11 vacancies.
Hmm.
Without any reasons, my lord, they did not fill up the 12 vacancy, my lord.
That's correct.
Yes.
So let us take it that the 12 vacancies for general category.
Yes,
Then also you will not get it. There is someone above you.
yes. One is above me. my lord.
Yes. Let us take it that it is for reserve category. Then also you don't get it.
Yes.
From viewed from this angle or that angle, you don't get it.
But my humble submission is that, my
Is
lord,
that not? Is it not? Mr.
6 for reserved, 6 for unreserved. They filled up only 5 vacancies in the unreserved category, my lord.
All right. So
And-
how are you agree?
And another thing is that, my lord, my lord, they selected 3 women candidates under women reservation.
Oh, you are Mr.
Yes, thus, my lord.
Yes, that's how are you aggrieved? Tell me that. They might have done this, they might have done that. All right. But how are you aggrieved? Even if all that you are saying is accepted by the court, even then, the 6th vacancy will go to the other person who is above you. He has not
Yes.
come before the court. So no mandamus can be issued to appoint you. Why should the court entertain the petition?
But my lord, the 30% reservation that has been
Do
totally
it in
ignored.
an academic discussion, not in a court of law. Convene a conference and deliver a lecture on that, not in a court of law. Your client doesn't have any right. You agree with that? Do you agree or not?
To some extent, my lord.
Acha, to what extent you don't
The
agree?
thing is that, my lord, if the 30% reservation is to be followed, my lord, then at most, my lord, they could have selected 2 women candidates, my
That
lord.
is correct.
But they selected
All
3,
right, so
that will be
that means
50%.
there could be one more vacancy in the, in the unreserved
two.
category.
2, that will be 2.
No, he says that one is still vacant.
1 is still
There's six-
vacant. And 3, my lord, women candidates,
But his main prayer is to, my lord, set aside the entire selection.
selection list.
But
That's
he's
why
not
my-
made them party. He want that all selection list will go, but they are not made.
But
party.
at the time of filing,
He's
my
a
lord, they
little
were,
confused. Which way to start? He wants some relief, but he knows it's difficult.
no, my lord, I have challenge on 2 counts, my lord. First is that, my lord, 11 vacancies were filled up, 1 post left out without any reason.
All right, we'll issue rule. We'll hear it in due course.
My lord.
Heard Mr. S. Das, like counsel for the petitioner, peruse the averments made in the writ petition. The grievance of the petitioner is pertaining to the selection process resorted to by the respondents for filling up the vacant posts of
Peon, my lord.
peon in the establishment of district and session judge South Salmara, Malkachar. Wide advertisement notice dated 11/2/2022. Mr. T.J. Mohantal and senior counsel.
For 2 and 3, my lord.
A Burua has appeared on behalf of respondent numbers 2 and 3
2 and 3.
and has questioned the maintainability and has submitted that the writ petition is devoid of any merit. He, however, prays for some time to obtain instruction and file affidavit. Similar is the stand of Mr. Hazarika, learned counsel for the respondent number 1. In view of the above, issue rule returnable in 8 weeks. Since the respondents are already represented, no formal notice is required to be sent. Extra copies be furnished to the learning department counsel. Is this case for hearing in usual?
My lord, name of the standing council, High Court may be
By
sworn.
by reflecting the name of standing counsel, Guwahati High Court.
Leave it.
Because
Highly obliged.
I think 14 and 15.
at a line, pendency of this writ petition shall not be a bar for the respondents to proceed in the matter in accordance with law.
Please, Lordship, my lord. My lord.
Yes.
My lord, the petitioner is working, my lord, the security officer in the CIT at Kokrajhar, my lord. My lord, he was engaged, my lord, by in a walk-in interview in 2/4/2018,
So your
my lord.
grievances service has not been regularized.
Regularized, my lord, that they are going, my lord, already, my lord, remove me, my lord, but there is no security, they are going to appoint some other person in place of me, my lord. Because they have made an advertisement 23rd February 2024. My post has not been advertised, that security officer, which is a permanent post.
So they have already removed you.
I remove it.
When-
My
when-
time has been over, my lord, that's,
All right.
and they have not discontinued me, my lord, from 3/3/2024.
So if your term is over, then what is your?
My lord, because my lord, their post is not advertisement, they are going to replace by someone, my lord, on ad hoc basis. Till then, let me
So you
continue, my
want
lord.
that the court should tell them that even if you don't want a security officer, you must advertise that post, and then the petitioner will apply and then consider the petitioner an appointee.
My lord, requirement is there, my lord.
My lord, and there is two earlier, my lord, they challenged the advertisement, my lord. It was that advertisement was withdrawn, my lord. And it was part of security officer and other officers, my lord. Subsequently, my lord, these are the other posts, my lord. We advertised, my lord, on contractual basis, my lord, and they are appointed, my lord. Yeah, due to pending of the writ petition, my lord, this post is not advertised, my lord. And now, my lord, this from the security officer for outsource, my lord, we are continuing. There is no intention to appoint the other person, my lord. The lordship record.
He also knows he doesn't have any case.
Yes,
He
madam.
wants an order from the court.
Yes, no,
We are
My
operating
lord,
in
they
the
are
system.
outsourced, they are, my lord, engaged.
Earlier, the
Till then, my
council
lord,
used to say we don't have a case. Now, the council knows he doesn't have a case, but he will still test the court.
yes, ma'am.
If I can extract something,
My lord.
Mr. Sarania,
My lord. My lord,
They will
till then, my lord, let
No,
them
my lord, no,
do
no,
do the
no.
advertisement to them, let me continue because they are taking the security post, but outsourcing, my lord.
how are you bothered?
Yes, my lord.
You can't dictate them terms, whether they should have security in
No, my
or
lord,
outsourced.
if they are continuing that post on ad hoc basis also, I'm entitled, my lord, I'm continuing from since 2018, my
Your
lord.
term is over.
Yes.
No, my lord, one ad hoc cannot be replaced by an ad hoc, my lord, they are, if, my
No,
lord,
no. What
anything
replace?
found against me, my lord, that is different thing, but
Mr. Sarania, you want an order, judgment in this case? I will dictate it. These are completely frivolous.
now they are saying that they are going to advertise the post, my lord, after filing of the writ petition, my lord.
My lord, Indian
Heard
solicitor-
Mr. M. Sarania, learned counsel for the petitioner, also heard Mr. S. K. Mehdi, learned CEC appearing for the respondents, peruse the averments made in the writ petition. Mr. Medhi prays for some time to obtain
My
instruction.
lord, I have
and file-
already, last time also I took time, my lord.
All right.
Today I pressed.
Mr. Medhi to obtain instruction and file affidavit, issue notice returnable in 8 weeks. Since you are appearing for whom?
For all respondents, my lord.
Since Mr.
One,
Medhi
two,
has
three.
accepted notice for all the respondents, no formal notice. Extra copies be furnished. Heard on the prayer of interim relief, the said prayer stands rejected. List along with the other matter.
My lord,
It is there, my lord. Other matter also before this.
Yes. List along with
4 weeks, my lord.
8 weeks.
Item 68.
It's a plain and simple case of dismissal with cost.
Yes, my lord.
So you have won the case.
My lord.
You have succeeded today. Next day I'll dismiss it.
May it please, your lordship.
Yes.
My lord, this is a peculiar case where, my lord, a penalty has been imposed even before conclusion of the disciplinary proceedings. My lord, I am a deputy marshal at the Legislative Assembly, Assam State Legislative Assembly. And there is a set of rules governing our service conditions and other things, my lord. I'll come to that. My lord, when the session is not on, my duties and function. When the session is not on, all throughout the year, my duties and function are, my lord, include, my lord, the security management, protocol management of the speaker, other dignitaries. And then, my lord, to assist speaker, deputy speaker, legislative committee chairmen, etc. And when the, my lord, session is on, as a deputy marshal, my lord, my duty is centered on to issue pass to press journalists for the press gallery and to be in readiness for, my lord, maintaining security in the house. And of course, if necessary, under the order of the speaker, to, my lord, bodily lift the unruly MLAs and carry them out of the floor of the assembly, my lord. That is one of my duties. Now, my lord.
Is the petitioner strong enough to do that? There is no averment to that.
It has happened. It has happened. Now
All right.
I can claim privilege before your lordship, my lord. Their privilege will not attack me. I can make a statement like that. My duties, my lord, include to bodily lift unruly MLAs so whenever ordered by the speaker, and I have done it. Okay. 1 or 2. My lord, on 9th of June 23, my lord, I was surprised by receipt of a so-cause notice issued to me, which your lordship will find at page 25. It's by, my lord, Secretary, Legislative Assembly. It has come to notice of the authority that today, 8, it was issued next. You have supposedly shared, lordship will mark these words,
Yes.
of CCTV footages with the media without seeking permission of the authority. It does not state what footage and shared, if at all, admitting, assuming, with whom, without seeking due permission of the assembly. As you are aware that without approval of the authority, no CCTV footages should be shared. This indicates your unethical intention which amounts gross violation of official norms protocols having disclosed footages being a responsible officer of the assembly. This so-called notice is issued against you as to why any of the penalties envisaged section 26, actually it should have been rule 27.
Yes.
Of the Secretariat Rules 86 should not be imposed. My lord, section 27 is, it prescribes, my lord, penalties in a disciplinary proceeding if any delinquent is found guilty at the culmination of the proceeding. Then it asks for reply. Then immediately, instantly on that said, immediately on receipt, I gave my denial, my lord, at next page 9 on the same day, Annexure C. I would like to inform you that I have received a so-called notice with wide as letter number so and so. It is come to notice that my name is involved in CCTV footage sharing with media without due permission. As I would like to clarify you that I was not involved in the CCTV footage sharing with media, and for my defense and safeguard, I request you kindly to share the CCTV footage, which they have not mentioned, my lord. Now, what this footage is all about? It is not even about any activities inside the entire assembly campus. This footage. Lordship, kindly have a look at paragraph 7, where I stated at page 8. What the footage is all about. Paragraph 7, page 8.
Yes.
came to know that a motor accident of a school bus had occurred behind the assembly hostel adjacent to the Legislative Assembly House. School bus. My lord, there is a Jalabad, this thing. Had occurred behind the MLA hostel adjacent to the legislative, which resulted in the death of a school student. My lord, that created a furor in the media also. A crowd gathered, police also arrived, course of investigation also entered the CCTV control room, seized footage of the accident. Be it mentioned that on that particular day, the petitioner was attending his daily work, so-and-so. As such, petitioner's name was linked with the allegation that he had provided CCTV of the incident to some reporter is mischievous manipulation to malign petitioner's service conduct with ulterior motives. Petitioner states that allegation leveled against him in the aforesaid notice did not have any iota of truth in view of the fact that apart from the duties and functions added to his post as deputy marshal, petitioner didn't have any written orders to supervise the personnel manning of the CCTV room, which as a matter of fact is under the control of a private party, namely so-and-so computing, and not by the assembly staff. It is pertinent to mention here that CCTV control room is situated inside the assembly campus and manned by two technical operators, namely so-and-so, engaged by the aforesaid company. Pertinently, the CCTV control room entrance is towards the roadside in between gate number 14 and 7 in front of the road near the new MLA hostel and is open to access by outsiders, passers-by on the street.
Right now, which is the order you're challenging here?
Here, my lord, the so-called notice, it was issued. Then I replied with all this, my lord, I replied, this is all these things in paragraph 7, I replied, my lord.
Yes.
Then I have annexed the photographs of the CCTV room to the authorities of that particular day, which your lordship will find at page 31 to 32 to 33. This is the CCTV room.
Yes.
It is adjacent to the wall of the campus. Then, my lord, 34, next page, my lord. This is how the people are working inside the CCTV room, and any passerby on the street, my lord, towards the Ganesh Mandir side, lordship has seen that, can go and enter into the CCTV room. Now, my lord, be that as it may, after this, I gave my detailed reply also, which your lordship will find at page 31. This is the reply. Lordship need not read all the paragraphs. I denied. Then, my lord, this reply I gave on 14/6. Thereafter, my lord, nothing happened. Nothing moved.
Yes.
No list of evidence, if any, given to me. No list of witness. No definite charge sheet was issued. No inquiry officer appointed till date. Then, my lord, to my dismay, while I was, my lord, receiving my salary for the month of August 23, I found that the usual increment, annual increment from July 23 has been withheld by them. Nothing proceeded after my reply, meaning thereby they might have been satisfied with my reply or not satisfied. But the initial show cause notice was at initiation of a disciplinary proceeding. My lord, my reference, I replied, what happened? So, my lord, you are not paying me the increment which is due to me. And my lord, increment is one of the punishment under the rules, my lord. There is a separate rules of the.
All right, so
They cannot do it. my
that is
lord.
your grievance. There is no order stopping your increment.
Nothing has been communicated to me, my lord, and it has.
I will obtain instruction next week, my lord.
That will be better. Let it come as motion, my lord. Because withholding of increment, my lord, in a way affects two things: my dearness allowance and, my lord, my contribution to the, my lord, pension scheme, new pension scheme. It has multiple effects.
When do you want it, Mr. Chutia?
My lord, next Friday, my lord.
Next Friday is holiday.
Holiday again.
Let it be the Monday next.
Monday next.
That will be.
Today.
No, my lord, let it 1st of April. Let it be on 1st of
Day
April.
after tomorrow holiday.
Do you want to,
No,
1st of April is better avoided when it is for instruction.
no. It may come this week also, if possible. If you can.
2nd April, 2nd April.
If you can take instruction.
Yes,
from
yes,
there
sir.
to-
Now election time now. It will take some time.
The assembly has got
All
nothing.
right, we'll have it on 3rd April and you please obtain instruction. Not
Third-
Mr.
third.
Supervisor and Senate Council, it's said by Mr. Council and
New cycle.
Council and a council appearing for the petition. Here was the amendments made in the petition. The primary grievance of the petitioner is that his annual increment has been withheld since the month of August 2023.
Since the month of, my lord, it commences in July, August, yes, August,
2023.
along with my
Without
salary in August.
Following the due process of law. On the request of Mr. T. Petition and Advocate Assam, This matter is directed to be listed again for motion on 3/4/2024 so as to enable him to obtain concrete instructions, bracket, written instruction, bracket close, informing this court as to the veracity of the allegation, and if so, the basis for withholding the increment of the petitioner.
Additional provide me
Two
extra
extra
copy
copies of the writ
Yes,
petition
now,
will
now,
be
right,
furnished to Mr.
right,
Chutia
obliged,
during the
obliged.
course of the day. Yes.
Kindly motion matter matter three.
None appears for the petitioner even on second call during the course of the day. This matter therefore stands adjourned for 2 weeks. Yes.
Item 10.
Yes.
2011, my lord, last occasion, my lord, he was asked to explain the delay, why delay is there.
Lordship, this petitioner is from Kuklajar, and in 2011, he was the victim of the ethnic clash. And in fact, the
So petitioner is aggrieved by what?
agreed by the withhold of one annual increment.
See, when was it done?
It was in 2011.
2011.
DP was conducted in 2011. Order was passed in 2012.
Hmm.
Accordingly, appeal was deferred, but
Where is the order? 2012. Where is the order?
It's 36.
page 36.
Hmm. So you are challenging an order of 23/12/2011 by filing a writ petition in 24.
Lordship, I'll file additional affidavit to explain the period. This opportunity may be given to me.
All right, we'll issue notice keeping the maintainability open.
Lordship.
Take down, Mr. So-and-so and a counsel appearing for the writ petitioner. Peruse the amendments made in the writ petition. The petitioner is primarily aggrieved by the order dated 23/12/2011 issued by the Commandant of the 7th AP Battalion, Charaikola, Kokrajhar, withholding one annual increment of the petitioner with cumulative effect. Mr. T.C. Chutia, learned additional senior government advocate Assam, has questioned the maintainability of the writ petition by submitting that the relief sought for in this petition is barred by delay and laches. The learned government advocate, however, prays for some time to file an affidavit asserting the maintainability of the writ petition. In view of the above, issue notice returnable in 8 weeks. Since Mr. Chutia has accepted notice and appeared for all the respondents, no formal notice is required to be sent in this case. Extra copy of the writ petition, requisite in numbers, be furnished to the learned government advocate Assam within 3 days from today. The question of maintainability of the writ petition is kept open and shall it be gone into at this stage of admission hearing. Not fine.
Okay.
11.
I pray for some further time. Can it be on 5th, madam, next Friday, 5th of April? It's regarding my reinstatement in service, madam. He was arrested, so he's under deemed suspension.
No order is passed, lordship. Till date. No order
On
of suspension has been issued, lordship.
Yeah.
No
You
order of
want it to be posted on 5th.
5th.
All right, Mr. A.M.S. Majumdar is present for the petitioner. Mr. B. Gogoi, learned standing
NHM,
counsel,
my lord.
NHM. 6 posting of this matter again on 5/4/2024. So as to give him one more opportunity to seek instruction. The matter fair allowed, list accordingly.
Item 12.
Yeah, please, your lordship. Lordship, this is second round of litigation. In the first round of litigation, the honorable court was held that lordship, though there was a restriction of 5% compassionate appointment, lordship. Such restriction will, however, not applicable in the case of the present petitioner. Lordship, your lordship will find at page number 58 is the relevant prayer of the judgment, lordship.
So what is to be done? We issue notice and you.
Yes, your lordship.
Right, heard Mr. D. Sharma, and counsel for the petitioner, peruse the amendments made in the writ petition. The grievance of the petitioner is on account of rejection of his claim for appointment on compassionate ground by the SLC, despite the order passed by the court in the earlier round of litigation. Uh, You are also there in this case?
3 and 4. 3 and
I am
for 1, 2, and 5 here.
Mr. Agarikar, learned counsel, appearing for respondent number 1, 2, and 5, and Mr. Agarikar, learned SC Industrial Department, appearing for respondent numbers 3 and 4, have both prayed for some time to obtain instruction in the matter. NOM 6 weeks, since the respondents are represented, no formal notice, extra copies.
Hello, please.
For admission, item 17, part 1.
My pleasure. In this case, a birth, the birth certificate, there is a birth certificate of 15/6/1964. So far this case is concerned, it is a case of premature retirement. The petitioner was an employee of Guwahati Municipal Corporation. He was retired in the year 2021. Now, in terms of his birth certificate, he should have attained at the age of 60 years in the year 2024, 15 May 2024. Now, my learned friend initially questioned the genuineness of the birth certificate, and your lordship asked me to produce the original birth certificate. I produced that, and then my learned friend considered that it is a genuine birth certificate. But one contention that has been raised by my learned friend was that they transferred from the official record, service record, that he was appointed in the year 1980. So if it is so, then at that point of time, his age was 16 years. So a person who is a minor cannot be appointed in the year of 16 years. On that point, your lordship asked me to have some instruction in this regard. Well, I have gone through the relevant provisions of law. Now it transpired that there is nothing, if we go by Article 24 of the Constitution of India. For the time being, if my lordship.
Okay, Mr. Dasgupta, so the matter will have to be heard and judgment delivered, right?
Yes.
We'll do it tomorrow.
All right.
But please be wary that if the appointment is found to be illegal, it will lead to forfeiture of his retirement benefits.
Oh, that's all right. If the law
If it is established that he was 16 years on the date of appointment, his pension, his retirement, everything will have to be forfeited. That's
that is
the
up
law.
to your lordship.
No, that's the law. That's the law, because these things can be done only when an appointment is valid as per law, right? So if a person is appointed at 16 years by your own showing, that means he was appointed at an age when it was barred under the law, under the constitution.
No,
So
that is I beg to differ.
all right. So are you available tomorrow? Can we take?
No. Tomorrow, yes, sorry. Any day, Lord. For the timing, will be Article 24.
Article 24. Give me the constitution.
May I go?
Yes, please.
No, I may be wrong then.
No, it's not, Mr. Dasgupta. It's not a question of right or wrong.
Right.
This is a constitutional court.
Yes,
Any
yes.
judgment will have a repercussion in the system that operates.
No, everybody is.
All I am telling you that I remember of some decisions which I'll definitely check up. That if it turns out that the initial appointment was, for example, I'll tell you one thing. There are cases when a driving license granted to a person underage, 25 to 30 years back, when it was detected, the license was wiped off and the person has to start from a learner's license. Because if the initial entry is illegal, then all current and future benefit will have to be stopped.
That is correct.
So if it turns out that your client was appointed under 18 years, then it is constitutionally not permissible. Somehow it has happened. But since he has rendered service, he will get his salary. But future benefit cannot be given. That is a risk he runs if he wants to press this petition. That is all I am saying. If it turns out,
your lordship has
because the court cannot say that all right, his appointment was illegal, but forget it. Let him get whatever it. That the court cannot.
No, for that purpose,
it has to be established that initial appointment is illegal.
No, but your own birth certificate shows
Yes,
that.
my own version is this. And it is their version is also that. I cannot go against the record produced by them. Despite that, Lord, I would like to venture one argument. Everything is admitted.
Yes.
Article 24, prohibition of employment of children in factories, etc. No child below the age of 14 years can be employed to work in any factory or mine or engaged in any other employment.
That has nothing to do in your case. Your client was engaged under the service rules of GMC. That rule will say whether it was permissible or not. If at that time it was permissible or there was no age bar, you sail through. If there was an age bar at that stage, then there is difficulty.
To tomorrow.
Have you understood the question?
Next week, Lordship.
It is now established that he was appointed at an age of around 16 years.
He is trying to establish, in fact, Lordship.
What is your stand?
No, in the year 83 itself, a medical board was constituted for the purpose, and it certified that on entry, his date of birth was 18. That was the medical board. Now he is trying to establish another date of birth. If that is allowed, Lordship, he will work for more than 44 years.
So that's why tomorrow we'll fix it. Can you just get the copy of the rules which was in force at that time? That's what I'm pointing out to Mr. Dasgupta, that this could have a very adverse consequence on his client. If it is found that he was underaged and the rules required 18 years, his pension, etc. will be forfeited in this proceeding. We have no doubt about it. The court is bound to do it because there are already similar decisions of the Supreme Court. The court is bound to do it.
The Lordship may fix another date.
Another date. When you tell us?
Any date. Somebody Lordship only.
On 19, Lordship.
Huh?
19, Lordship.
No, 19, no, don't do it. You can have it on 18th.
Lordship, in fact, record was furnished to me, but today morning I could not press out the record.
Why not next week?
Next week's possible.
Say 4th of April.
Lordship.
Except 2nd April, not any other date.
4th of April.
Lordship.
You understood the point, Mr. Dasgupta. Have you understood the point?
Yes, Lord.
You can't have it both ways.
Your Lordship's view is that if the entry is illegal, then I will forfeit all the benefits which is accrued to me after retirement. That is pensionary benefits.
From tomorrow onward, the date of the judgment, future benefits will have to be. But this is a court of equity, will not permit any recovery. But future benefit has to be stopped.
That's all right. If law is that there, then I'll have to face the consequences.
Because that's the problem. That is the problem your client is facing. If his version is accepted, then he loses a lot of money. If his version is rejected, then he's the gainer. If the court rejects your version, then your client will succeed. If the court accepts your version, then your client is in deep trouble. That's why I wanted to give you the opportunity to reflect on that. You see, the court is not against your client, but the legal principles will have to be applied. Of course, you are free to argue, but your 24 has nothing to do here. That is in factories.
Just before that, I would like to refer one section of Apprentice Act 1961.
Then we'll hear it.
Any other date? No?
All right. Let's have it on 24th April. 24th April.
24th?
April. All right. Mr. Dasgupta, Learned Senior Counsel, present for the petitioner. Mr. P. Naik, Learned SCGMC, submits that the records which were with him has been returned, and therefore he be granted some time to obtain the records afresh. In view of the above, when on the request of the Learned Department Counsel, registered to list this writ petition for admission hearing on 24th of April 2024 as a fixed item. Please check up this legal issue. We don't want any injustice to be caused to anyone.
Yes.
But the writ court's judgments will have a ripple effect. So we have to go by the legal principle.
Section 3 of the Apprentice Act. I will refer
All right.
on that.
You argue on that.
Obliged.
Yes.
May please, Your Lordship, my senior election code number 20, maybe timing, possible maybe timing.
Lordship, Last occasion, I had the instruction that she will pay a lump sum amount of 1 lakhs. Your lordship has asked me to take further instruction. So I have convinced them to settle it on 1.5 lakhs.
Acha, our senior is, let
Lost.
him come. Wait for him. Wait.
Item 19.
The issue involved here is the selection to the post of MBI. Advertisement provided diploma in automobile and mechanical engineering. Rule also provided diploma in automobile and mechanical engineering as the minimum qualification prescribed.
This will take some time.
Take some time.
We'll hear it. Let the other matters be over.
Sorry. Look, do some matters fix in another.
Oh, wait, it will be
Yes,
before
yes.
two.
I'm sorry. Much obliged.
Item 20 and 21.
Made these, my lord.
Yes.
My lord, in this matter, the official liquidator was supposed to prepare and submit a report. This is the application under section 468 of the Companies Act. Today, I seek for some more time, my lord. There was a shifting of the office, therefore everything got delayed. They're shifting it.
Mr. A. Sanilal and counsel appearing for the official liquidator bracket OL submits that due to shifting of the office, the report could not be prepared for producing before this court. As such, 4 weeks further time be granted. Mr. R. Borpujari and counsel is present for the respondent company. Respondent and does not have any objection. The prayer is allowed. In view of the above, let this matter be listed again after 4 weeks.
Obliged.
Respondents, my lord, in the meantime, they have complied with all the instructions given by the liquidator.
That is perhaps already recorded.
Yes, yes, it is already recorded. I'm so obliged.
Obliged.
Item 22 and 23.
The petitioner is agreed by the gradation list, my lord, dated 19/10/21 and 6/12/21, my lord. Whereby the petitioner has been placed at serial number 122, my lord. And her immediate junior, my lord, who had joined in the cadre after her, my lord, has been posted at serial number 84, my lord. Well, what had happened, my lord, in 2017, my lord, there was an promotion exercise that has been undertaken by the APDCL authorities, my lord.
So you are appearing for 126.
Yes, my lord, for the official.
You filed your affidavit.
We filed our.
You have admitted his case.
No, my lord, we said, my lord, the promotional exercise, the date of reckoning is the date of the last promotion, my lord. Admittedly, the petitioners herein were promoted on a later date than the people who actually been given the benefit of the promotion, my lord, up to the higher.
Have you filed any rejoinder?
They've not filed.
Not,
it.
my lord.
You want to file or not?
We'll file it, my lord.
No, it's up to you. You want to file or not?
We'll file, my lord.
Otherwise, I'll take it up today itself for disposal. You want to
We'll
file
file
or
a
not?
we'll file a short reply, man.
Huh?
We'll file a reply.
All right. Mr. B. Chaudhary, and counsel for the respondent numbers 1 to 6 submits that counter affidavit on behalf of his clients has already been brought on record. You have for Miss C. Sharma is present. Learned counsel is present on behalf of respondent number 7. However, on the request of Mr. D. Kalita, learned counsel for the petitioner, this matter stands adjourned for 2 weeks so as to enable him to file a rejoinder.
Fine.
List accordingly.
Deeply pleasure.
23 is
File a
similar.
rejoinder and then we'll have
Item 23 is similar, man.
same.
Same.
So same order in item 23. List along with item 21. File a rejoinder because that is the controversy. You have to dispute it and substantiate the dispute. Otherwise, the court will have to accept their claim.
My lord, will oblige.
Item 24.
My brother, lordship. Your lordship, may kindly see your lordship's order dated 11/1/2024.
Yes,
My lord, I'm sorry, my lord. I have just received a communication from the department, my lord. They have this. It comes from my lord, state enquiry officer, my lord. They have completed, my lord, and they are submitting the enquiry report to the department, maybe by today, my lord. That is what I have received an instruction, my lord. That was completed, my lord, and she was
no,
sick.
but that is what you said on 11th of January also.
Exactly, my lord. In the meantime, my lord, this state, my lord, this is not with us. It is with the state enquiry officer. We have given it to the for an impartial enquiry, my lord. The department did not keep it, my lord. We have given it to state enquiry officer. So, my lord, our information was that, my lord, the state enquiry officer has completed. In the meantime, my lord, that lady who is the officer, she was out of station. Then there are bereavement in the family, my lord. And this is the written instruction I have received just now, my lord, from the state enquiry officer that it's completed and it's being sent to the department, my lord, the enquiry.
Mr.
report, my lord.
Chakraborty, learned
So,
counsel for the
my lord,
petitioner
my
is
prayer would
present
be,
and has invited the attention of this court to the order dated 11/1/2024, passed in this proceeding to submit that despite the earlier order of the court, no copy of the enquiry report has been furnished to his client till today. Mr. Ardhar, learned standing counsel, this is which department?
my PWD, my lord.
PWD Assam submits that a copy of the enquiry report will be handed over to the, will be furnished to the petitioner by 2nd of April 2024.
My lord, make it, my lord, fifth, my lord, they are sending it, my lord. So
By
today,
5th of April 2024. In view of the above assurance given by Mr. Dhar, registry will list this matter again as a fixed item on 8th of April 2024.
Obliged, sir.
25.
May I please, your lordship? My lord, I am appearing on behalf of my senior H. Buragohai. He is a bit indisposed today. Kindly accommodate us for today.
my lord, we have received our instruction, my lord. We need time to file our affidavit.
How much time?
2 weeks, my lord.
My lord, there is a similar matter. Let this matter may be taken up along with that matter on 3rd of April.
What is the similar number? Case number?
WPC number 2831 of 2022, 2023.
WPC number?
2831 of 2023.
2023. All right. So we'll give him some time.
Yes.
The BU vacation is after the BU. The learned counsel for the petitioner seeks little accommodation in this case on the ground that the arguing counsel is out of station. Mr. D.K. Roy, learned counsel appearing for the respond numbers?
7, my lord. 7
Respond number, you don't know.
or 7, my lord.
She will tell you who you are appearing for. Why are you looking at her? You don't have the brief.
My lord, the extra copy not served to us, my lord. I have sent the copy to the SEBA.
You have not given extra copy to him.
Yes.
Huh? Respond number 7 submits that he has received instructions and therefore be granted 3 weeks time to file affidavit. Therefore,
For respondent of 1, 2, 3, and 4.
Mr.
T. Thakuria, lordship.
T. Thakuria,
Thakuria, lordship.
learned standing counsel secondary education, is present on behalf of respond numbers 1 to 4. And Mr. T.C. Chutia, learned additional senior government advocate Assam, has appeared for respond numbers 5 and 6. On the request of Mr. Roy, this matter is directed to be listed again on 26th of April 2024 so as to enable him to file affidavit. The other respondents may also file affidavit in the meantime if so advised. On the request of learned counsel for the petitioner, registry to list this case along with WPC number 2831 of 2023, which is stated to be analogous to the present proceeding.
Obliged.
Item 26 and 27.
May you please, your lordship?
Lordship, I beg to mention for, I beg to prefer adjournment. The other side, government has filed affidavit in opposition to which we have to file our affidavit in reply. So we need some time.
The learned counsel for the petitioner prays for and is granted 2 weeks time to file rejoinder in response to the counter affidavit filed on behalf of the respondent number 3. Mr. T.C. Chutial, and additional senior government advocate Assam, is present on behalf of the official respondent. Prayer is allowed. Let the matter be listed. Official respondent and does not have any objection to the prayer for adjournment. In view of the above, this petition is directed to be listed again after 3 weeks. In the meantime, rejoinder be brought on record. Yes.
28.
The petitioner has already retired from service. He was a physically handicapped person. He was promoted after order of this honorable court. After this long period, they have promoted after filing contempt petition. Petitioner plead for retrospective benefit of promotion.
No, he was promoted when?
I have been promoted by order dated 24th February 2023 for 1 month only. Petitioner is entitled promotion since 2015. And he has been examined medically twice regarding his disability. Thereafter, the contempt petition has been filed. Lordship will remember. As per Lordship direction, he was appointed before 1 month of his retirement.
So he has already retired.
Lordship, only 1 month he got the promotion benefit.
Right.
He wants retrospective benefit of promotion from the date of the order of which honorable court to consider his case for promotion within 3 months.
No, but first of all, I don't think that is the correct legal position. But have you challenged the order dated 24/2/2023?
Lordship, I have challenged that on the ground that I should be a promotion from 2015. I have challenged that order because Lordship will remember.
No, that doesn't happen. You can get seniority benefit retrospectively, but no promotion like that. Promotion is always prospective. Only the seniority benefit is given. Anyway, we'll examine it. No relief is permissible. The relief you are praying for is not going to be possible from this court because that is not the mandate of law. You can get seniority, but anybody will come and say that already you have promoted me, but you should have promoted me 10 years back. So now I have retired, give me my promotion. That's not permissible legally. If a junior is promoted and you have been ignored.
My junior has been already promoted. That is why my case.
You get seniority, that's all. What will you do with the seniority now?
Seniority has no role to play now.
Then
Only,
there's nothing in this case.
only Lordship, my financial benefits should be given, fixing the scale, Lordship, with effect from.
You try it somewhere else, not here. It's not going to work out. Law doesn't operate like that. You can't get anything. But there is a problem. Your promotion is still temporary.
At least, not temporarily, but as per selection by the APSC.
But there is no order of regularizing your promotion. That will create problem for your client's pensionary benefits. You better focus on that. Instead of asking for something which I don't think you will get.
At least I should get the seniority and fixing of scale, Lordship. That is why I will get the benefit.
Question doesn't arise. Question. I can pass an order right now.
I'll
But
check up.
you will have your problem with the pensionary benefits because your client's promotion is temporary and he's retired. So he is not, his promotion has not been regularized.
Because APSC on recommendation.
AG will catch hold of you. What do you want?
So I'll try. I'll try to. If amendment is required, I will make the amendment.
Okay. We don't want your client to suffer. So therefore, just pointing it out. I've seen the order. His promotion is temporary.
So last promotion order is temporary on the APSC selection. On the recommendation APSC.
I appreciate your grievance. But your grievance doesn't make out a case. Your client is unhappy. That's what we understand.
Petitioner junior has been promoted earlier. They have passed speaking order one after another.
He can get seniority with effect from the date when
if seniority is given,
he cannot get promotion with effect to 20 years back. That's not permissible.
No. I am praying that if fixation of pay scale is fixed with retrospective benefit, he will get the retirement
impermissible under the
retrospective benefit. Lordship.
That's impermissible under service duty.
I'm paying the financial benefit.
Absolutely. That should be an order of the court.
Lordship.
Court cannot promote. The reason is the court cannot promote you. Court can only ask them to consider.
Consider my case for promotion.
That's all.
Lordship.
But that consideration is always in currency and perspective. The court cannot say that consider his case for promotion 20 years back. No such order is permissible, or 10 years back,
No,
or
no.
5 years back.
If Lordship seniority is given and pay scale is fixed as per my seniority, then I'll get the pensionary benefit.
No, it doesn't happen like that. No. It can't be that you are promoted today and you will get the pay scale which was available 5 years back. No. Because the court cannot promote you 5 years back.
I understand. Lordship.
Promotion is their job. The court can only say that you should be considered for promotion. That's all. And if your consideration was illegally ignored and your junior is promoted, then it becomes an issue under Article 14 and 16. Therefore, the protection is to give you the seniority with effect from the date your junior was promoted. It can never be that, okay, 2024 you have promoted me, but according to me, I should have been promoted in 2016. So give me my promotion from 2000. That's absurd. That can't be done. On the prayer of Mr. S.K. Goswami and counsel for the petitioner, this matter stands adjourned for 4 weeks, so as to enable him to examine the legal issues and address the court. Mr. T.C. Chutia, learned additional senior government advocate Assam, Mr. P. Nayak, learned SC Finance Department, Government of Assam, and Mr. Hazarika. You are also appearing in this? No, I do not know. Are present on behalf of the official response. Mr. Goswami, I am lightening your burden.
I understand.
I am giving you the gist of the legal position. You work on that. If you see that there is nothing, don't unnecessarily toil. These orders are no use. This will never be implemented. And these are not correct orders. The court orders should be correct orders. It should be based on correct principle.
I understand. Lordship.
You understand me? But your client has a problem because his promotion has not been regularized. That will create a problem with his settlement of his pensionary dues. Someday there will be a recovery and then you will have to run from here to there. That is the grievance you can, that is the remedy you can pursue in the court.
That is where Lordship injustice has been caused. And after Lordship intervention, my promotion has been given before 1 month.
No, that we understand. We understand that. But now he is retired. He cannot be, see, it can't be, clock cannot be set back. That's the unfortunate part of the reality.
And petitioner is a physically handicapped person.
We understand that, but clock cannot be set back. That's the reality. You cannot set back the clock. When a remedy is permissible, only then it can be given by the court, not otherwise. There are many things in this world where you cannot set back the clock. Yes, next matter, please.
Obliged.
Item 29.
Yes,
Pensionary matters.
Huh?
First wife, second wife.
first wife, second wife. Very difficult matters.
It is since almost 45 years, she was receiving maintenance amount. It went up to apex court on the point of Section 7 of the Hindu Muslim Marriage Act, that under Section 25 is not applicable to the Muslim married wife. Ultimately, it was decided in our favor, and she was drawing till husband died, and it admitted.
So you are for the first wife or second wife?
First wife.
You are for the first wife.
First wife.
What is your grievance?
I need pension. Second wife is getting pension. She was made nominee. First wife has been residing alone since 1979 and only receiving her maintenance amount.
And when did the husband die?
2022. Husband died 2022.
We will file the affidavit, affidavit of opposition. Really, I am appearing for the respondent number 6, private respondent. My lord, we got divorced declaring Tin Talaq, my lord. Declaring Tin Talaq on 1977.
Who got divorced? Who?
The first wife. I am the second wife, my lord. Thereafter, I married with his husband, my lord. I will file the affidavit of opposition and give me some time.
Even the order is also there.
What does the Supreme Court say? Where is the Supreme Court?
Supreme Court has, I could not file it because it is a very long matter, 91. Sabanu case. Immediately after it was Sabanu case.
Not in your case.
In my Sabanu, no. Subsequently, after deciding Savanu case, my case was also decided. The Muslim wife receiving 125 maintenance is not supposed to go, maintenance will not be discriminated on the point of this one, and the section 7 of Muslim Marriage 1935 Act.
But this is pension, this is not maintenance.
Maintenance, actually maintenance amount has been already, she was receiving till husband died, maintenance, 4,000 rupees per month. Therefore, it is clearly establishing that she is the first wife, and it is admitted first wife. There is
No,
not.
what does the rule say? The
First-
rule will have to decide, no?
Rule
Who
will
get
first
the
wife will get.
pension?
First wife will get. First wife will get.
First wife or nominee?
Nominee is only for the purpose of record that there is a nominee. Yeah, nominee was really, first wife was not in a good book of the husband. Therefore, nominee will come, second wife will come as a nominee.
He wants to file an affidavit. How much time you want?
Only thing till that time, the pension may be stopped. Interim relief may be granted.
Pension may be stopped.
Pension may be stopped in favor of second wife.
Second wife.
Well,
Now, how does he benefit from that?
At least in that case, they will already more than 1 year passed, 2 years passed.
They will also feel the pain.
There is pain.
That's what you want.
Yes, Lordship.
Good, good.
my lord,
You want the 226 court to play a role in fulfilling your desire,
Lordship,
that they should feel the pain.
I have 4 courts order, honorable courts order, indicating that I am the first wife.
All right. Heard Mr. B.K. Bhagwati, learned counsel for the petitioner. Also heard Mr.
and more.
So N. Burma, learned counsel appearing to the respondent number 6, who prays for 3 weeks further time to file counter affidavit. The prayer is not opposed by the petitioner's counsel, hence the same is allowed. Mr. S.K. Medhi, learned CGC, is present for the respondent number 3. Mr. P. Nayak, who learned SC Finance for respondent number 1, and Mr. Azarika, C.S. Azarika, learned Government Advocate Assam for respondent numbers 1, 4, and 5. This matter is directed to be posted again after 4 weeks as a fixed item for admission. Parties to exchange pleadings in the meantime. The writ petition will be taken up for disposal at the stage of admission here.
Deep levels.
Item 30.
May please your lordship. Lordship, the matter pertains to as he was working as LDA from 15/12/1989 to 30/11/1993, lordship, without any salary, under the establishment of Director of Employment and Craftsman Training, lordship. The respondents are bound to regularize his service for that said period, lordship. Although he has been reinstated and appointed as press on 1/12/1993, lordship, as per the High Court Order 7/1/1992.
Yes.
Passed in Civil Rule 2090/1989, lordship. There is no service break from his initial date of appointment on 22/3/1988 till his retirement on 31st March 2022, lordship. Hence, the petitioner have filed this writ petition for non-payment of salary and non-regularization of the said period.
Just 1 minute. Petitioner was appointed when?
My lord, I have received the pass now.
15
Be allowed to file the affidavit, my lord.
15.
How much time?
I received the pass now, my lord.
When you are appearing for whom?
For respondent number 4, my lord.
So let him file affidavit then.
Yes, lordship.
All right, you take down, Mr. D.
D.
Burman,
Burman.
learned counsel appearing for the writ petitioner. Mr. S.P. Das, learned counsel appearing for the respondent number 4, prays for 4 weeks time to file affidavit by submitting that he has already received para-wise comment. Considering the nature of grievance expressed in the writ petition, the prayer stands allowed. This writ petition be listed again after 4 weeks so as to enable the respondents to file affidavit responding to the grievance expressed in the writ petition.
Highly obliged, lordship.
Item 31.
That is your lordship. My lord, this matter relates to compensation appointment, my lord. The petitioner, father of the petitioner, my lord, he was serving as a grade 4 employee in the PW office, my lord, at Silsar, and he was expired on, my lord, on 19/2/2016, my lord. And
Yes.
hereafter, my lord, the petitioner submitted an application before the respondent number 5, my lord, on 11/4/2016. And his application was, my lord, forwarded
for consideration to the office of the respondent number 3, my lord, on 28/8/2016. Now, thereafter, my lord, as the case of the petitioner was non-placed in the DLC, my lord, therefore he approached before this honorable court, my lord, and filed a writ petition. And that writ petition was disposed of, my lord, with a direction to be placed in the next
So
DLC,
what is
my lord.
your instruction, Mr. Nayak?
Lordship, in this case, we have filed one affidavit. Lordship, may kindly see page 24, Lordship.
Page 24. Yes.
Of the affidavit, Lordship. Lordship, no post was available in the department, Lordship. Also in other offices in this district. Under compassionate ground, DLC CASA directed the undersigned to take suitable action as per clause 15 of Gov. OM dated so and so by sending pending proposals to the head of the administrative department, take up the matter with other department of the government of Assam to provide at an early appointment of compassionate ground to those in waiting list. Lordship, hereafter, Lordship, only the deputy commissioner will be able to tell.
Administrative department, Lordship, here it is the executive engineer, Lordship. So administrative engineer means the chief engineer or the department, the PWD department.
Lordship, Lordship, no issue, Lordship. I can apply instruction also, but only one line I am pointing out, Lordship. In the district, it's going to be a district level appointment, Lordship. In the office, no vacancy is there.
Excuse me.
And in other office in the district are also no vacancies are there.
But then of course, it is the deputy commissioner who has to say.
He has sent it to the administrative, Lordship.
This is an information.
No, he may send it, but he cannot, the PWD officials cannot say whether there are vacancies in other department.
By
That they cannot say.
by sending the pending proposals to the head of the administrative department, that is what is.
No, you obtain instruction.
My lord.
Mr. Alloy Learned Counsel for the Mr. DJ Alloy Learned Counsel for the petitioner is present. Mr. P. Nayak, Learned Standing
PWD.
Counsel PWD has invited the attention to annexure Roman 2, capital Roman 2 in the affidavit filed by the respondent number 5 to submit that now it is for the deputy commissioner of the district to verify if vacancies are available in other departments in the district. In view of the ongoing process of holding the Lok Sabha elections, Mr. C.S. Hazarika prays for 8 weeks time to obtain instruction in the matter. Prayer allowed. Let this matter be listed again after 8 weeks.
For order, item 32.
May it please your lordship. My lord, in this IA number 2575, I have filed for transfer of this proceeding before the NCLT. What happened in this case, Your Honor, the Companies Act having amended in 2018, and by virtue of section insertion of 5th provision to section 434(1)(c) of the Companies Act, if any application is filed before this court for transfer, that matter is to be transferred to the NCLT. May I refer that notification, my lord?
What is your?
I'm appearing for the respondent number 4, not for the company. I think the Chaudhary is appearing for the council. Lordship, this is not a case for transfer because whatever it is, it's covered by the company's transfer of pending proceedings rule 2016. That is what is covered by. Rule 5.
No, you are appearing for respondent number 4.
4.
I
One
only
of the
find
10.
2 respondents here.
I am for director.
In the IA, there are only 2 respondents, 2 opposite parties. Is it not?
No, my lord, 4 are there.
4. You are referring to IAC 2276.
2575, Lord. IA 2575.
So IA 257.
My lord. And this.
And who is appearing for 1, 2, and 3?
One, Mr. Chaudhary. 1, 2, and
The transfer petition may be started. We have filed that is 2276/21.
Started means what? What kind of start?
Because I have sought their consent that I will be paying for 10 months. Since they were pressing, I have not mentioned it, but I am led by learned senior counsel Ken Chaudhary.
I will pass final order in this matter in next 10 minutes. What do you mean by they'll start and you will finish? This is what? This is a running race or what? You have not made a prayer for adjournment, so let him argue. I'll pass an order either allowing or dismissing him. That's all. Yes.
My lord, this is the
Nobody has
notification.
prayed for adjournment, so no question for adjournment.
I have not, Mr. Chaudhary is not there.
Only I was paying, not on the transfer, on the.
Mr. Kandelia, this kind of prayer you cannot make with the court. That I want this, I don't want that. This doesn't happen. There is no prayer for adjournment. We'll hear the matter. That's all. Yes.
My lord, this is the notification which has come on 17th August 2018. I given the copy and section 39 on the last page of this notification, Your Honor. Last page. Section 39. May I read, my lord?
Yes.
In section 434 of the Companies Act 2013, as substituted by paragraph 34 of the 11th schedule to the Insolvency and Bankruptcy Code 2016, in subsection 1, in clause C, after the proviso, the following proviso shall be inserted, namely, provided further that any party or parties to any proceeding relating to the winding up of companies pending before any court immediately before the commencement of the Insolvency and Bankruptcy Code Amendment Ordinance 2018 may file an application for transfer of such proceeding, and the court may by order transfer such proceeding to the tribunal, and the proceeding so transferred shall be dealt with by the tribunal as an application for initiation of corporate insolvency resolution process under the Insolvency and Bankruptcy Code 2016. So by virtue of this insertion of the proviso, Your Honor, any party may file an application for transfer, and that entire proceeding is to be transferred in the NCLT. In this matter, Your Honor, I have relied a Supreme Court's version, as my learned friend has
So
pointed
you are
out.
for the petitioners.
I am petitioner.
You have filed the petition for winding up of the
Winding up of it.
winding up of which company?
Winding up respondent number 1.
Respond number 1.
1.
And who is respond number 2 and 3?
2 and 3 are unnecessarily inserted. That is the
Unnecessary.
administrative
But who
office.
has
And
done it unnecessarily? You have done it.
my lord, earlier other advocates was there.
You are doing it and saying it is unnecessary.
My lord, because registered office is sufficient, my lord. So far winding up petition is
Okay.
concerned.
Mr. Kandelia is appearing for respond
Appearing
number
for
1.
1 and 3.
And what is the grievance against respond number 4?
4 is also, my lord, one director was inserted and they have filed.
It is
the
also
petition.
unnecessary.
My lord, I did not want to.
3 unnecessary, 1 necessary.
For the winding up petition, my lord, registered office is sufficient, my lord. But rightly or wrongly, once they have inserted.
Then why have you included them?
My lord, I want to just press one Supreme Court judgment, my lord.
Yes. Where is the company petition?
In this case, Your Honor, 2 important questions were settled down. Proceeding for winding up of a company are actually proceeding in name. And so 2 questions were raised. That is at page number 4 of this judgment, Your Honor. What are the circumstances under which a winding up proceeding pending on file of a high court could be transferred to NCLT?
Which para you are referring to?
Para number 12, Your Honor, page 4 of this judgment, Your Honor. Page 4 of this judgment. Yes, apna copy diya.
Where is this is the judgment. Which judgment you are referring to? Caledonia Jute and
Yes, my lord.
And you are referring to para?
My lord, page number 4 of this judgment. After 12, para 12, there are issues. 2 issues were framed in para 13, my lord. For consideration, 2 issues were framed by the Honorable Supreme Court.
And what is the answer to this issue?
Answer, my lord, what are the circumstances under which the winding of proceeding pending in file high court can be transferred? The circumstances in this case held that after insertion of this fifth proviso, at any time, it can be transferred.
Where is the
By
finding?
any party, by
Where is the
any
finding?
party. What happened in this case, Your Honor?
Where is the finding?
My lord.
Which para?
Para 43, my lord. Forty-three, 46 are the concluding paragraph, Your Honor. May I read, my lord? Forty-six is important, my lord.
We'll transfer it. It is his choice where he wants to institute it.
But this condition, transfer of proceedings only if the notices are not served. Once it's served, it continues here.
See, Ms. Hazarika, he is asking for transfer. We'll transfer it. You raise the question of maintainability. He suffers. Before
My
the,
lordship, when we have come, all pleadings completed, it's at the final stage now. Or is he
then
trying
we'll wind up the company today itself. If that is what you want.
No, it's, I mean, is he speaking
He
it
is,
to
he
the
is
forum,
primarily
lordship, but this,
pursuing a remedy
the
against the
com-
respondent number
because-
one.
yeah.
He doesn't want to pursue it in this forum. He wants to go to NCLT and he says these changes in the statute. So if it cannot be transferred, if there is, if the NCLT has jurisdiction, then certainly it has to be transferred.
No,
If the NCLT doesn't have jurisdiction, his petition
Yes,
fails.
lordship, only up after a point, the NC, it can be transferred. Only if the notices are not served as per rule 26 of the company code rules. That is the rider. And this is a rider in the company's transfer
But have you
proceedings.
filed any objection to his IA?
That is my objection, lordship. You can't just come and ask for a transfer. It's like it's a forum picking, lordship. You have filed all this while you're carrying on till 2022. This notification came out in
No, no, I
2017.
understand. I'm asking in the IA, is there any objection filed by your client?
Yes, I think everyone has filed.
They filed. They
Everyone
have
has
raised the
filed.
other issues
Everyone has
on the
filed.
merit, my lord.
He raised also on
May-
merits, also on top.
Only one point, my lord. My point raised by my learned friend regarding rule 5.6 of the company's transfer of pending proceeding rules 2016. That is not applicable in this case after insertion of proviso fifth. And for that purpose, Your Honor, para 46, as I referred this
Then the
judgment.
matter, it's
Para
a heavily
46
contested
line.
matter. We have to write out a judgment. Is the senior engaged by,
My lord.
is also not there. We'll fix it on some other day and take it up.
Fine.
When will your senior be available? Take down so and so for the applicant. Mr. G. Khandelia, learned counsel appearing for the OP numbers 1, 2, and 3. Submits that the senior counsel engaged in this case, namely Mr. K. N. Chaudhary, is unavailable today and therefore the matter be posted again in the second week of April 2024. Ms. M. Hazarika, learned senior counsel, as stated by Ms. A. N. Rahman, has opposed the IA by contending that this is not the appropriate stage to move an application for transfer of the proceeding to the NCLT. After hearing the submissions made at the bar, this court is of the view that the issue raised in the IA will require detailed consideration. Since the learned senior counsel for the respondent numbers 1, 2, and 3 is not present today, on the request of the respondents counsel, this matter is directed to be listed again on 29th of April 2024 as a fixed item. Yes.
I am appearing for respondent number 1 only, my lord.
Order has been complied with.
No, not yet, my lord. It matter in the finance department, my lord.
Item number, you are
30.
appearing for whom?
JBK, item 33. Actually, respondent 4 and 5 have been newly implemented. No notice has been given to them.
None appears for the petitioner on call. Mr. Bhattacharya, learned counsel for the respondent number 1 submits that the matter is now pending before the finance department, but no notice has been issued to respondent number
4 and 5.
respondent numbers 4 and 5, who are the authorities responsible for expediting the matter. Although the petitioner's counsel is not present to confirm the said position, yet a perusal of the record prima facie indicates that notice is yet to be issued to respondent numbers 4 and 5. As such, issue notice to respondent numbers 4 and 5 returnable in 8 weeks. Petitioner to take steps accordingly.
Highly obliged.
Item 35.
May I have your lordship? Lordship, in this case, lordship, I may be allowed to implement the new incumbent as respondent number 1, lordship.
On the request of Mr. A.M.S. Majumdar, learned counsel for the applicant, 2 weeks time is granted to file interlocutory application for implement of new incumbent in the office. Mr. D. Nath, learned counsel is present
For
for
respondent
the
number 5.
respondent number 5. And Mr. S. Datta for respondent number 2. List accordingly.
36.
May I please your lordship, my lord? I am appearing for respondent number 2, my lord. Respondent number 2 has been transferred. The new incumbent has joined in its place, my lord. Kindly implement the new.
May allow 2 weeks time.
The learned counsel for the petitioner prays for and is granted 2 weeks time to file an application for implement of the new incumbent who has joined as
Commissioner PNRD Joy Shivani.
Commissioner PNRD, Commissioner for the Government of Assam PNRD Department. Mr. A. Bhattacharya is present on behalf of the respondent number 1.
Obliged.
Item 37.
Yes.
Your lordship, in terms of the in compliance of the judgment, they have submitted they have issued the NOC. They have not yet released me from the post. So I cannot join ICR. I am stuck now, your lordship. They have written on piece
Practice
of
that
paper.
NOC is issued, my lord. In the meantime, a department inquiry proceeding has started. He has challenged it, that is stayed by the petition, by the court. Now, my lord, NOC though issued, my lord, there is a department proceeding is pending. So in the, my lord, vigilance clearance, they have stated that it is provisionally clear because in the order is stayed, they cannot even close it also, my lord, that is stayed by the High Court. So already his prayer is there, my lord, in the connected writ petition that the contempt should be listed along with the writ petition, my lord, on 18th of April. My lord, fact is that the NOC issued. Now DT is pending, that inquiry is pending and stayed by the this honorable court in a proceeding, my lord. That is WBC 688623.
The effective portion is a page numbers 14, para 16.
Yes.
In view of the aforesaid facts, your lordship.
Other, my lord, they cannot also release him at this stage, my lord, because of this.
Only thing that remains now is the relieving portion, which they are not issuing that relieving order. So that I can join in ICR. On papers, they are okay. But on ground, the position is somewhat different.
So there is an order to allow him to join.
Yes, my lord, that is there, my lord. Without vigilance clearance, my lord, even he'll release, my lord, it will be not benefited him, my lord, because of
So
that.
who is the officer to release him?
The officer commanding.
Correct. I'm directing personal appearance.
My lord,
yes.
only my thing is that, my lord, NOC issued, my lord. Now that is pending before the Honorable High Court and proceeding stayed by this court, my lord. In another writ petition, my lord. Because of that, my lord.
Proceeding stayed, what proceeding stayed?
My lord, departmental proceeding inquiry has been started by, initiated. That is, has been challenged by him. That is stayed by this court. Now, how can they give vigilance clearance, my lord? NOC issued, my lord, because of this technicality, my lord.
Mr. D. Boral and counsel is present for the petitioner on the request of Mr. K.K. Parasar.
On
This
18, my
matter will be listed on 2nd of April 2024 along with
along with WPC number, my lord,
Otherwise, the WBC otherwise is fixed on 18th.
18 already fixed.
WBC number.
6886 of 2000.
Then we'll fix it on 18th.
My lord.
Then 18th. May list this matter again on 18/4/2000 along with WBC number
6886 of 2000.
6886 of 2023.
23. I'm sorry, blood.
38.
I have entered appearance in this case, my lord. Lordship may kindly give me the 2 weeks time, my lord.
For whom? You have appeared for whom?
For the respondent.
Sole respondent.
Sole respondent.
Mr.
Emma Sharma.
M.R. Sharma, learned counsel is present for the petitioner. On the request of Mr. D. Nath, learned counsel who has entered appearance for sole respondent. This matter stands adjourned for 2 weeks. So as to enable him to obtain instruction and file affidavit.
Much obliged.
39.
Lordship, in this matter, I seek one week time, Lordship. We have received instructions.
Mr. H.R. Ahmed, learned counsel is present for the petitioner. On the request of Mr. R.M. Das, learned counsel appearing for the sole respondent. This matter is directed to be listed again after 1 week. Plus to enable him to obtain complete instruction.
Obliged.
40.
What correction you want?
My lord, that the names were not reflected in the order sheet, but the cause list, my lord, the common order was passed on the day. My lord, the cause list at page 16, serial number, serial number 4, lordship. The name of the petitioner applicant is at serial number 4. And when the judgment was passed by lordship along the petition, that name was by clerical, it was clerical mistake, I think, my lord. At page, next one is my lord, order of your lordship. Page 8.
Whose name has not been reflected?
My lord, this applicant's name. My lord, page 16 may kindly be seen, my lord. Page 16 of the cause list. Serial number 3, Ranjit Kumar Sharma and 14 others. And then this serial number 4, Premature was in the cause list, and the order was, common order was passed, my lord, on that day. And but the names of this Premature and then Bhaskar Nath and Parikshit Das were not reflected.
So this order is passed in WBC 6977 of 2023.
Yes, madam.
So in that case, there were altogether 15 petitioners.
Madam.
All of their names are there in the order.
Now, some of the names were dropped. This name, this applicant's name were not, my lord, typed by the applicant.
When we input this case number in the website, we get this order. This 6977 order with wherein the petitioner were absent. We the website this number 7099. We get the order of 677, but there is the petition is not.
7099, the petitioner's name is not there.
In the entire order, when you click on the website.
Okay. So there is no problem with 6977.
No.
But the problem is in 6999. 7099.
7099 and below, below, we also filed the
Acha,
application.
if I write, Mr. R.C. Sekhar, learned counsel has appeared for the applicant and submits that although this court has passed common orders disposing of item numbers 3 and 4 of the matters listed before this court in the cause list dated 18/12/2023, annexed as annexure numerical 2 to the IA. Yet, with regard to WPC number 7099/2023, bracket item number 4, the name of the writ petition is not reflected in the cause title of the order, as a result of which the petitioner in that case has not been able to avail the benefit of the order. The learned government advocate, Mr. C.S. Hazarika and Mr. R.M. Das,
Lordship, respondent 192.
learned counsel for the respond numbers
1 and 2.
1 and 2.
Social justice.
Along with Mr. D. Upamanyu, learned SC Health Department are present and have not seriously disputed the above submission. It appears that there is a technical glitch, as a result of which
562.
the name of the writ petitioner in WPC number 7099/2023 is not reflected in the cause title of the parties in this in the certified copy. Be that as it may, registry to verify, rectify the defect if any, and list the matter again on 8/4/2024 with necessary report. Let them rectify it. On rectification, it will be open for the registry to issue a fresh certified copy, to the applicant's counsel by including the name of the writ petitioner in WPC, that 7076.
Time being admission matters, item 18.
So he is willing to give 1.5 lakhs to, I think that's a good amount. Put it in fixed deposit and she will be happy. Nowadays, there are many facilities, medical treatments are already there. Otherwise, we'll have to write a judgment. Your client may get half or get nothing. That I cannot say right now.
My lord, Lordship may pass order, but Lordship may not go down the consenting order. That is up to your Lordship.
Take down. Heard Mr. M.O. Mahmood, learned counsel appearing for the writ petitioner. Also heard Mr. D. Das, learned counsel appearing for the respond number 7. What about the other counsels? The learned standing counsel, Education Department, Assam. Who is the Elementary Education Department standing counsel? Can you please call him? Mr. So-and-so, learned standing counsel, Elementary Education Department, Assam, has appeared on behalf of respond numbers 1 to 5 and Mr. P. Nayak, learned SC Finance Department, Assam, for respond number 6. Full stop. The writ petitioner herein is the mother of late Arup Das, who was serving as a teacher at Devhati M full stop E full stop school full stop. The late Arup Das died a premature death, leaving behind his widow as respond number 7 and a minor son. And a minor son, is it?
Yes.
Minor son.
Yes, Lordship.
Minor son. Full stop. Under the pension rules, now under the service rules, the respond number 7, being the widow of the deceased employee, had received an amount of rupees 14 lakhs. The petitioner has approached this court by filing this writ petition by contending that being the mother of the deceased and considering the fact that her son was driven to commit suicide on being provoked by the respondent number 7, she would be entitled to 50% of the amount paid to the respondent number 7 by the government as service benefits. Full stop. Hence this writ petition. Full stop. It is not in dispute that the respondent number 7 is the widow of the deceased employee and she is having to look after her minor son. Full stop. It is also not in dispute that the petitioner is presently staying with her other son. Is it?
Her sons, but they're unemployed.
Her other sons, and she is at least receiving partial support.
She is receiving pension also.
And she is also receiving pension from
10,000.
Family pension.
10,000.
family pension
From her husband.
on account of her husband,
That's
on account of her deceased husband. Full stop. Taking note of the peculiar facts and circumstances of the court of the case, this court had passed order dated 24/1/2024, requesting learned counsel for the contesting parties to obtain necessary instruction as to whether the matter can be resolved amicably. Full stop. Taking note of the concern expressed by the court, Mr. D. Das, learned counsel for the respondent number 7, submits that although his client will have to look after her minor son, including his health and education for the rest of the life, till he attains majority, yet so as to assuage the feeling of the petitioner, she is willing to part with a sum of rupees 1.5 lakhs from the benefits received by her on account of deceased Arup Das. Full stop. Mr. Mahmood submits that the amount will be meager and has prayed for enhancing the amount to rupees 5 lakhs. The learned counsel for the petitioner has, however, submitted in his usual fairness that the petitioner is receiving family pension at this point of time. After considering the submissions made at the bar, this court is, and by balancing the equities, this court is of the opinion that without going into the technical issues raised by the parties in this case, ends of justice will be met and the ends of justice will be met if the respondent number 7 is directed to part with a sum of rupees 1,50,000 as one-time payment to be made to the petitioner within 60 days from today, so as to give her some comfort for the loss of her son, loss of her earning son. Full stop. The learned departmental council, as well as the learned standing council, finance department, have also not raised any objection to such an order. In view of the above, this writ petition is disposed of by providing that the petitioner will receive a sum of rupees 1.5 lakhs to be paid by the respondent number 7 in her bank account.
also, can it be in bio bankers? Bankers.
Bank account. So and so, the respondent number 7 will issue single banker's check for an amount of rupees 1.5 lakhs and hand over the same to the writ petitioner within a period of 60 days from today. Thereafter, the petitioner shall not have any further claim against the respondent number 7 on account of service benefits, if any, received by his widow. That is the respondent number 7 hearing. The writ petition stands dismissed.
And if you
Nice.
Yes. How many more? So at 2.
The issue here is already on the last occasion, Lordship.
It's all you have to start from the beginning.
I'm just refreshing your Lordship, my Lord. Lord, they initially issued a notification, page 23, prescribing HSSLC with 3-year diploma in automobile and mechanical engineering. Page 23.
This is the first advertisement.
What is the date?
Date is, my lord, 13 October 2020.
Yes.
The qualification your lordship will find page 23 down below. Minimum essential qualification and minimum essential qualification and relevant portion will your lordship will find page 24.
So minimum qualification HSLC.
It's double that is high secondary with 3-year diploma in automobile and mechanical engineering from recognized institute. Then, my lord, they issued a corrigendum that your lordship will find page 30. (13 11 2020). By this, they have included degree holder also. Initially, it was higher secondary, then they have included matriculation also. It's HSLC stroke it's double SLC with 3-year diploma in automobile mechanical engineering or B.Ed B.Tech automobile mechanical engineering. Thereafter, they issued a notice, page 31, by which this corrigendum was advertisement was cancelled.
Yes.
13/10/2020 advertisement was cancelled by this notification, page 31, 4 May 2022. And page 32 is the fresh advertisement, 25 May 2022. Educational qualification, HSLC, HSSLC with 3-year diploma in automobile mechanical engineering for a recognized institute of Government of Assam.
Yes.
Now we applied pursuant to, after the corrigendum, we applied against this post, my lord. When after the cancellation and in this fresh advertisement, they did not allow us to participate. In that situation, we approached this honorable court. This honorable court, my lord, was pleased to pass an order directing us to appear in the selection process. And out of the 6 petitioners, my lord, 4 got selected. Now the present situation is 4 posts your lordship was pleased to direct, 4 posts to keep aside, other posts they can fill up, my lord. That is the present situation. Now these 4 petitioners, they are the degree holders, my lord, in mechanical engineering. And rule your lordship will find relevant portion, page 54. It's a rule, the nomenclature of the rule is Assam Transport Service Rule 2003.
Where is the rule, page number?
It starts from page 38.
Yes.
The Assam Transport Service Rules 2003. Relevant portion in the rule your lordship will find page 54. District Transport Officer, a degree in Arts, Science, Commerce of a university recognized by the government, and motor vehicle inspector HSS LC with 3-year diploma in automobile or mechanical engineering from recognized institute of Government of Assam and Government of India and also duly recognized by AICTE. So our pleaded case before your lordships is that, my lord, since we have degree
The post is MVI.
yes, motor vehicle inspector.
Yes.
Our pleaded case before your lordships is that since we have degree in mechanical engineering, which is admittedly a higher qualification than the diploma holder, so that presupposes acquiring of the diploma, my lord. That is our pleaded case. My lord, on the last occasion, the respondents, they placed one judgment of Honorable Apex Court before this court, my lord, Zahur Ahmed Rathar. Within para 26 and 27, the Honorable Apex Court said that it is not the function of the writ court to go for equivalence of the qualification, that whether degree will equivalent to diploma or vice versa. My lord, in my humble submission, my lord, we are not required, because rule also doesn't say diploma with 3-year diploma in automobile mechanical engineering or equivalent. Rule doesn't say so. My submission is in a different perspective, my lord. We are not required to go into the equivalence issue, my lord. But my submission is that, my lord, since the petitioners admittedly holds a degree in mechanical engineering in the same discipline, had the discipline would have been different, then, my lord, the question and the issue involved would have been, a conclusion would have been different. Since we have the degree in the same discipline, mechanical engineering, in that view of the matter, my lord, it is presupposed that we have the diploma. And there is another, my lord, I have given one notification which provides for lateral entry of the diploma holder into the degree stream, my lord. And that notification was also considered by the Honorable Apex Court one judgment. I'll just play. The issue is very simple, whether we can induct into this recruitment process by virtue of our degree qualification. And
that's not the issue. I'm putting you on notice.
Yes.
So that you don't feel that I didn't get a chance to argue.
No.
The issue is this. The refusal on the part of the respondents to allow your clients to take part in the recruitment process, whether it is arbitrarily done, illegally done, or is it legitimately permissible? That's the only issue. Please listen to the query.
Yes.
The court will not even go into all these submissions, whether this is equivalent, whether BE degree should have been treated as diploma plus something. We are not going into that. Is it illegal? Supposing there was a mention of diploma in so and so and equivalence, including BE.
Yes.
If they were rejected, then it would have been arbitrary, illegal. But they are also bound by the rules as much as your clients are bound. The rules should have been what you are saying, but the rules are not what you are saying.
Yes.
Listen to the contention.
Yes.
It will help you in some other case.
Yes.
The problem is, in these matters, the rules actually puts out the policy of the government in these cases. Correct. Rules puts out the policy of the government in such cases. The policies may be legitimate, valid, might be outdated, but the courts cannot supplement its ideas in the rules and policies. That's not permissible. This court wants that the BE degree holder should be allowed, but the court cannot do it. As a judge, I may want it, but as a court, I cannot give that direction because it will be illegal. Because this is a matter which lies within the domain of the government. Our job as writ court is only to see whether the government is or the departmental authorities are discharging their duties as per the constitution and the laws and rules framed thereunder or not. What should be the law? What should be the rule? What should be the policy?
That is in the diagram. Lord, my Lord, I know my
So you have
line
got
is,
the answer.
Ye-
Now you argue.
yes. Lord, my line is very thin, my Lord. To escape, my Lord, the hole is very narrow. But what my submission or my argument before your lordships would be, even then in similar situation wherein no equivalence is given, the endeavor of the Honorable Apex Court was that to get because in 3-4 cases, my Lord, there are cases of High Court as well as Apex Court, my Lord. The endeavor of the court was to, if a person is selected, to get him an entry somehow. My Lord, I'll just place to get an handle, to take a handle from the rules and get into him. But this submission of the respondents that this equivalence is not there. Perhaps, my Lord, your lordship is correct that the rules, a diploma
You will
in,
not deal with that equivalence argument.
no, it's not
You
required
can
to.
argue both sides. I will not get into that.
I am only on pragmatic interpretation of the rules because it will not be interfering with the rules. It is an interpretation of the rules whether this degree holder who is which is a higher qualification, whether that will presuppose or not of acquiring the diploma. It's not interfering with the rule or whether they have committed, apparently if the rule is such that they have not committed any mistake, my lord. But the thing is that I am on the point of interpreting the rules in a pragmatic manner so that
that adds something more to the rules.
No, my lord. It's not something.
Degree cannot be read into the rules by the 226 code. That's the end of the matter.
It's not, my lord,
It
reading
cannot
down.
be. If it is done, it will be illegal.
It's not.
Supreme Court, I'm not here to comment. Supreme Court has powers under 142, etc., etc. But as far as the power under 226 is concerned, the court, as I have just mentioned, is to only see whether they have meted out arbitrary and discriminatory treatment to one set of. It is about equal protection of law to all citizens of the country. That's all. The courts are only to see that. The courts are not to judge whether it's the right policy, whether the rules should be these, the rules ought to have been changed.
No, my lord.
No.
But if the courts of law has held that a degree in a particular discipline can be presupposed to acquire a diploma, my lord, isn't that, my lord, wrong on the part of the respondents to not allow us to participate, my lord, or not to deny us appointment, my lord? I'm just trying to interpret this particular provision. Similar provision, one judgment I'll just place, my lord, I have given on the last occasion.
Yes. Yes, please.
Yes. This is, my lord, 2021 SCC online, SC 291. It is, the name of the parties are Punik Sharma and others versus Himachal Pradesh State Electricity Board. Well, there are judgments of our own High Court also.
That's just a minute.
And
yes. Yes, which paragraph you are relying upon?
my lord, facts your lordship will find in para 2. Whether a degree in electrical engineering, stroke electrical and electronics engineering is technically a higher qualification than a diploma in that discipline, and whether degree holder are eligible for appointment to the post of junior engineer electrical under the relevant recruitment rules is the issue that falls for decision in this appeal arising out of a common judgment and judgment of the Himachal Pradesh High Court. As is evident, this issue is not novel and has an almost endemic tendency requiring judicial attention, albeit in myriad and diverse contexts. Para 3. The Himachal Pradesh Sub-Selection Commission, acting on the requisition sent by the Himachal Pradesh State Electricity Board, advertised 222 posts of junior engineer on 27/6/2018. Degree holder in concerned discipline applied for the post. After qualifying the written examination, they will call for verification of documents, but the final result was not declared. They approached the High Court in the writ proceeding, claiming that since they possesses educational qualifications that were higher than the prescribed minimum qualification, they could not be denied consideration. The diploma holders opposed this claim and argued that the qualifications possessed by degree holder was neither higher nor can be considered in the teeth of the recruitment rules, as also on the basis of the advertisement issued by the Himachal Pradesh Public Staff Selection Commission. The HPSAB adopted a neutral position. However, it highlighted that as per the applicable regulations, the minimum essential qualification provided for recruitment to the post of junior engineer was matriculation with diploma in electrical, electronics, and communication, computer science from recognized institute, board, university, duly recognized by central or state government. HPSAB further stated that the HPSSC could not traverse beyond the regulation and was bound to make recruitment in accordance with them. The HPSSC, which issued the advertisement and conducted the selection, opposed the petitions and asserted that degree holder could not be considered for recruitment. By the impugned judgment, the High Court considered the party's submission, the position in the recruitment rules and various decisions of courts besides its own decision, and concluded that it would be noticed that the Honorable Supreme Court has categorically held that normal rule would be that candidate with higher qualification is deemed to fulfill the lower qualification prescribed for the post. But the higher qualification has to be in the same channel, which is not the position in the present case. Therefore, the guiding factor while considering the case of higher qualification is thus, it must be in the same line. The degree in engineering is not in the same line as diploma in engineering, and it therefore cannot be considered as higher qualification. Judged in the light of the aforesaid exposition of law, a diploma in engineering and degree in engineering are two distinct qualifications, and the degree in the field in question cannot be viewed as a higher qualification than when compared to diploma in the field. Consequently, degree holder petitioners cannot be permitted to urge that they possess higher qualification, which would meet the requirement of specific qualifications specified in the rules of advertisement. In addition to the aforesaid, it would be noticed that the Respondent Electricity Board has itself not considered the degree in electrical engineering, electrical and electronics engineering to be superior to the diploma, and rather treated these to be two separate and distinct qualifications. And that is why it, by notification that so-and-so has amended the recruitment and promotion rules for the post of junior engineer, so-and-so, so-and-so. Now, your Lordship will kindly come to the rules in question in that case. Your Lordship will find para 18.
Yes.
It is under the heading analysis and conclusion. The relevant rules stipulating essential qualification for the post of JE were framed and brought into force on 13/11/2006. They repealed the then existing rules framed by HPSCB in 1996. The notification to the extent is relevant is extracted below. Milord, this clause 7 is akin to our case, Milord. Minimum matriculation with diploma in electrical, electronics and communication, computer science from the recognized institution, board, university duly recognized by central and state government. There is no or equivalent, my lord, here in this rule also.
Yes.
Then my lord will kindly come to para 19. The AICT circular, I also relied on this circular, my lord. Herein also that mention has been made. On 12/1/2007, the All India Council of Technical Education, AICT, prescribed that a student acquires a diploma in engineering through a minimum of 3 years of institutional study after 10+2 secondary examination. Diploma holders were to be academically equivalent to students who passed the first year of the 4-year engineering degree program. On 24/5/2010, by clause 11, the recruitment and promotion regulation applicable to HPSCB were amended, and they provided for essential qualification for promotion from the post of junior engineer electrical to the post of assistant engineer electrical, effective from 21/6/2012. The rules of recruitment and regulations were amended inter alia to the cadre of assistant engineer by HPSCB, providing two distinct quotas in the promotion quota. The existing quota of 6% available to this acquired AMI degree in electrical engineering qualification, etc., in service with minimum 1 year regulation, 1 year regular service after confirmation was reduced to 5% quota by the amendment. In addition, the promotional quota to the post of assistant engineer from the cadre of junior engineer was to the extent of 5% eligible for consideration. This quota was specifically identified as those who had completed their engineering degree before joining the service of junior engineer. Now, in the promoted post of the criteria for the promoted post are given assistant engineer. Now, you also will kindly come para 26, wherein the Honorable Apex Court discussed the previous judgments in on the issue regarding Milord this presupposition of. In all the judgments, Milord, the facts were that in what discipline? Because there is one judgment, Jyoti KK, wherein Milord the rule was given, and that rule prescribed that presupposition is permissible. And Honorable Apex Court, by relying on that rule, had come to a conclusion that higher qualification will presuppose the acquiring of the lower qualification. That judgment in Jyoti KK was distinguished in these judgments, which are Milord here referred. And the distinction was made on the basis of the fact whether it was in the same discipline or not. I'll just take your Lordship's para 26. In Anita Supra, this court was concerned with JBT teachers, where the minimum qualification was 2 years junior basic teachers training. Those with MSc, B.Ed and MA qualifications were held ineligible, looking at the nature of the job, i.e. teaching primary classes. Jyoti Supra was distinguished because the appointing authority had the option of considering appointment of persons with higher qualifications. Then Zahur Ahmed Rathar, which was placed by my friend on the last occasion, the post in question was Technician 3 in the Power Development Department in the state of Jammu and Kashmir. The relevant stipulation with respect to qualification was metric with ITI in the relevant trade. The appellant had diploma in electrical engineering and were included in the list of disqualified candidates. The qualification was metric with ITI, but the appellants before the Honorable Apex Court were the diploma holders. So in that case, in view of the discipline, the appellants, this resulted in litigation which ultimately culminated in the judgment of this court. This court held in the judgment, under the above provisions as well as the advertisement which was issued by the board, every candidate must possess the prescribed academic, professional, technical qualification and must fulfill all other eligibility conditions. The prescribed qualification for the post of Technician 3 in the Power Development Department is a metric with ITI in the relevant trade. The board at its 116th meeting took notice of the fact that in some districts the interview had been conducted for candidates with a diploma in engineering, while in the other districts candidate with a diploma had not been considered to be eligible for the post of Technician 3. Moreover, the candidates with an ITI in diverse trade had also been interviewed for the post. The board resolved that its meeting that only an ITI in the relevant trade, namely the electrical trade, is the prescribed qualification specified in the advertisement. And in that background, Milord, the Honorable Apex Court has held that the diploma holders will not be entitled. Then, Milord, paragraph 26 and 27 of that judgment was quoted. Now, my lord, will kindly come to this para 38, my lord. In para 38, all the judgments like PM Latha, Yogesh Kumar, Zahur Ahmed Rathar of the Honorable Apex Court, wherein, my lord, this proposition was, Jyoti KK's proposition was distinguished, has been dealt with. The consideration which weighted with this court in the previous decisions, i.e. PM Latha, Yogesh Kumar, Anita Supra, were quite different from the facts of the case. This court's conclusion that the prescription of a specific qualification, excluding what is generally regarded as higher qualification, can apply to certain category of post. It can apply to certain category of post. That means the discipline in which the degree qualification has been acquired has got relevance, my lord. Thus, in Lalita and Yogesh Kumar as well as Anita, those possessing degrees or post-graduation or B.Ed degrees were not considered eligible for the post of primary or junior teacher. In a similar manner, for technician 3 or lower post, the equivalent qualification for the post of junior engineer, i.e. diploma holder, were deemed to have been excluded in Jahur Ahmed Rathar Supra. This court is cognizant of the fact that in Anita as well as Zahur, the stipulation is Jyoti KK, Jyoti Supra, which enabled consideration of candidates with higher qualification, was deemed to be a distinguishing ground. No such stipulation exists in HPSEB rules. Yet a material significance is the fact that the higher post of assistant engineer, next in the hierarchy of junior engineer, has nearly 2/3 promotional quota. Amongst these individuals, those who had held degree before appointment as junior engineers are entitled for consideration in a separate and distinct subquota, provided they function as a junior engineer continuously for a prescribed period. This salient aspect cannot be overlooked. It only shows the intent of the rulemaker not to exclude degree holder from the consideration for the lower post of junior engineer. In the higher post of In the higher post of assistant engineer, there was a quota mark for junior engineers, degree holder junior engineers. The Honorable Apex Court Miller took the handle from there and derived a conclusion for their entry into the degree holders entry into the junior engineer stream.
Yes.
Although the rules provide that only diploma in the particular discipline can apply. So in my humble submission, my lord, what the Honorable Apex Court has finally held is that a degree holder is a higher qualification than the diploma holder, because without holding that, the entry would not have been possible, my lord.
Yes.
Without holding that, because if the degree holders don't have the higher qualification, and if the degree holders holding of a degree do not presuppose holding of a diploma, then this entry would not have been possible, taking handle that 5% quota is fixed in the higher post, and there is intention of the legislature. Here also, my lord, for the post of DTO, the qualification is graduation for the next higher post. You know, in a recent judgment, after this, a matter came up before my lord, Jammu and Kashmir High Court.
Yes.
Wherein, my lord, all the judgments, in fact, including the judgment of Jahur Ahmed Rathar Puneet Sharma, was also discussed in this matter.
Yes.
The qualifications, your lordship will find para 3. Pursuant to a requisition received from respondents number 1 to 3, the respondent number 4 issued an advertisement notice in the year 2019. Advertisement notice number so-and-so dated so-and-so was pertaining to the selection of various non-gazetted posts born on divisional cadre of Jammu of Government Medical College, Rajouri. Amongst the posts notified for selection for GMC Rajouri, one post is audiovisual technician in audiovisual aids, photographer and artist under open merit category, and one post of telephone supervisor under open merit category were also included. Similarly, for Government Medical College, so-and-so, advertisement notification dated so-and-so was issued by the respondent number 4 for making selection to various posts, which included one post of audiovisual technician in audiovisual aids under open merit category, and one post of telephone supervisor under open merit category. As per the advertisement notifications, following was the qualification prescribed for the post in question. The qualification.
What is audiovisual? Audio or audio?
Audio, my lord. There is a typographical error, my lord, here in that chart. The qualifications, diploma in electrical and communication from any recognized institute in both the cases. Now, what the High Court has held, my lord. Lordship will kindly come to para 12.
Yes.
The issue that has cropped up for determination in this petition is not free from difficulties. For there are several judgments of the Honorable Supreme Court pronouncing on the same issue, though in the context of different fact situations. There is no denial of the fact that law is well settled, that it is not for the court to lay down qualification for the post. The prescription of qualification as held in the case of Zahur Ahmed Rathar is a matter of recruitment policy, and the state as an employer is entitled to prescribe the particular qualification as a condition of eligibility. Undoubtedly, the state is entrusted with the authority to assess the needs and public service, and therefore it clearly falls within the domain of the administrative decision making as to what qualification would be laid down for a particular post, having regard to the nature of job associated with the post and other socio-economic prospects. Having said that, we do not want to survey the case law on the aforesaid points in issue. However, for the purpose of discussion on hand, we first need to determine as to what is the qualification prescribed for the post in question. Apparently, looking at the advertisement notification, the prescribed qualification is diploma in electronics and communications. Whether the prescribed qualification is fixed qualification, leaving no room for a candidate with the higher qualification in the same line to apply for the post, is a question to be pondered over. Be it noted that the government order prescribing qualifications does not put an embargo on the candidates possessing qualification higher than the prescribed minimum qualification. Now, I'll take your lordships to para 16.
Yes.
Before we advert to the aforesaid aspects of the matter, we need to clear the mist surrounding the legal issues determined by the tribunal in the light of the various judgments of the Supreme Court. Needless to say, the judgment in each case, even on a question of law, has invariably turned on the factual metrics presented in the case decided by the court. The issue as to whether a higher qualification presupposes the acquisition of minimum prescribed qualification cropped up for discussion before the Honorable Supreme Court in PM Latha so-and-so, so-and-so. The issue that was raised in the said case was whether the qualification trained teacher certificate required for the post of primary school teachers in the School Education Department of State of Kerala would be included in the qualification of B.Ed held by some of the aggrieved candidates who were declared ineligible to participate in the selection process for the aforesaid post. The Supreme Court, after analyzing the issue in the context of material on record, concluded that the B.Ed qualification could not be considered as a higher qualification than TTC, given the fact that TTC qualification was a distinct requisite qualification imparted to teach the small children primary classes, whereas the qualification of B.Ed was a training imparted to educate the students of higher classes. In a nutshell, the question of B.Ed was not held to be a qualification higher than the qualification of TTC in the same line. In this view was reiterated by the Supreme Court in the case of Yogesh Kumar, which was again a case in respect of qualification of TTC and B.Ed. In Jyoti KK versus Kerala Public Service Commission is a judgment of the Supreme Court, which is mostly relied on by the aggrieved candidates holding higher qualification like degree in engineering, who are not allowed to participate in the selection for the post prescribing diploma as a minimum qualification. Though the Honorable Supreme Court inter alia rendered the judgment in the context of Rule 10A of the relevant recruitment rules, yet the proposition of law that was laid down in the case of Jyoti KK Supra case was that a qualification of degree in engineering in a particular discipline presupposes the acquisition of lower qualification of diploma in the same line. And therefore, even where the minimum prescribed qualification is diploma in a particular line of engineering, a person possessing degree in the same line cannot be held ineligible to apply for the post. This judgment was, however, distinguished in the case of State of Punjab versus Anita, though the case was entirely different from the present one. In Anita's case, the court was concerned with recruitment to the post of JBT and ETT teachers, for which the minimum qualification prescribed was 2 years in junior basic teachers training course. And those with higher qualifications like B.Ed, MA, MSc, MCom, etc. were held ineligible. The Honorable Supreme Court, having regard to the nature of job required to be performed for teaching primary classes, came to the conclusion that the higher qualifications like B.Ed was not a qualification presupposing the acquisition of 2 years junior basic teachers training, JBT, which was entirely a different training meant for achieving different objective. Similarly, Zahur Ahmed Rathar's case was also distinguishable in its facts. In Zahur Ahmed Rathar's case, Supra, the post in question was Technician 3 in the Power Development Department, for which the qualification prescribed was metric with ITI in the relevant trade. The JK Service Selection Board held that the candidates possessing diploma in electrical engineering were ineligible. The aggrieved diploma holders went to the court and the matter ultimately landed before the Honorable Supreme Court. What was held by the Honorable Supreme Court is reproduced under. Under the above provisions, as well as in the advertisement which was issued by the board, every candidate must possess the prescribed academic, professional, technical qualification and must fulfill all other eligibility qualification. The prescribed qualification for the post of Technician 3 in Power Development Department is a metric with ITI in the relevant trade. The board in its 116th meeting took notice of the fact that in some districts, the interviews had been conducted for candidates with a diploma in engineering, and while in other districts, candidate with a diploma had not considered to be eligible for the post of Technician 3. Moreover, candidate with an ITI in diverse trade had also been reviewed for the post. The board resolved in its meeting that only an ITI in the relevant trade, namely the electrical trade, is the prescribed qualification specified in the advertisement. Apart from the judgment to which the reference is made by us herein above, there is a plethora of case law dealing with the issue in the context of fact situations presented in each case. The proposition of law, which we can say with some amount of certainty shall have universal application, is clearly laid down in Jyoti KK Supra and followed in the recent judgment of the Honorable Supreme Court in the case of Punit Sharma Supra. The Supreme Court has surveyed the entire case law on the issue and factual context in which the judgment in each case have been rendered by the Supreme Court, and has concluded that where the state as an employer prescribed a particular minimum qualification for the post, the candidates possessing qualification higher than the prescribed minimum qualification are eligible, provided the higher qualification is the same line. That is my submission. In other words, if the higher qualification possessed by a candidate presupposes the acquisition of lower qualification in the same line, such candidate cannot be held to be ineligible for the post on the ground that it does not possess the minimum prescribed qualification. It would be complete fallacy and contradiction to say that the candidate possesses a higher qualification which presupposes the acquisition of the prescribed minimum qualification, but does not possesses the prescribed qualification. In such a situation, court may not be required to substitute or read into the qualification other than the one prescribed. However, such finding can be returned by a court only when there is sufficient material and record to indicate that the higher qualification claimed by the candidate to participate in the selection process is in the same line as is prescribed minimum qualification. Before we look into the material available on record to come to such a conclusion in the instant case, we are also required to deal with the two other aspects highlighted by the learned counsel for the respondents, which are to cut out the correct ratio of judgment in Punit Sharma and misrepresentation. We are not concerned with that, madam. Now, para 21
Yes.
The decision of Punit Sharma, my lord, the paragraphs are quoted.
Yes.
Then my lord will kindly come. Para 26, last paragraph. My lord.
Yes.
In view of the discussions made above and having regard to the legal position adumbrated in Punit Sharma's case, we hold that for the purpose of the case in question, the qualification of degree in electronic and communication held by the petitioners is necessarily a higher qualification than the minimum qualification prescribed in the advertisement notification, i.e. diploma in electronics and communication, and that the higher qualification possessed by the petitioner is in the same line. We further clarify and hold that the qualification of degree in electronics and communication presupposes the acquisition of diploma in electronic and communications, which is the minimum qualification prescribed for the twin post in question. The petitioners were thus eligible to participate in the selection process. The tribunal has not correctly appreciated the position of law and has wrongly held the petitioners ineligible for the post in question. As a result, we allow this petition set aside and cause the order of the tribunal impugned in this petition by issuing a writ of certiorari. A writ of mandamus is issued to the respondent board to review the merit list for the post in question, having regard to the facts that both the petitioners are eligible for post in question and accordingly frame the final select list afresh. The respondent board shall do to issue the select list within 2 months so that the selected candidates are appointed without any further loss of time. We further provided that in case it is possible to accommodate the writ petitioners without disturbing the selection made, the official respondents may proceed accordingly, and judgment passed by us today notwithstanding. So here in our case also, my lord, there is no iota of doubt that we are degree holders and we possess higher qualification. Nobody is disputing that the petitioners do not possess a higher qualification. Now, issue is whether it presupposes acquiring of the diploma. In Jyoti KK, the ratio was laid down. But since rule was there, in subsequent judgments, the Honorable Apex Court in Anita, PM Latha, and Jahur Ahmed, the Honorable Apex Court held that it was turned on the basis of that rule. But that ratio remains. That ratio, that since they are holding a higher qualification, it presupposes holding of a lower qualification, that remains, my lord. That has not been taken away. In the given facts of the case, like in Jahur Ahmed Rathar, ITI and diploma, in that context, Honorable Apex Court has held that these are not higher, ITI is not a higher qualification. Then, sorry, my lord, diploma is not a higher qualification of ITI. Then it was distinguished. In all the cases in Anita also, in fact, in this High Court judgment, it was discussed how the facts were. In Anita also, B.Ed qualified candidates, they were denied because they wanted a certified course. So first the decision was taken that it is not a high qualification. Then entry was restricted. In Punit Sharma, my lord, when the Honorable Apex Court allowed the degree holders to enter into the selection process, what was the foundation? The foundation was that degree and diploma are same. Degree holder presupposes the diploma. Without, my lord, recording a finding on that, that entry could not have been given merely because 5% post in the cadre of assistant engineer are earmarked for, my lord, lower post of executive engineer, junior engineer, may be earmarked. But unless and until this decision or deliberation or conclusion is there, that these degree holders are presupposed to acquire the diploma, my lord, that conclusion could not have been drawn by the Honorable Apex Court. So that is why my submission before your lordships is that it is nobody's case that we are not higher qualified, my lord. We are not required to go into that or equivalent, my lord. We are there. Going by the ratio of the Honorable Apex Court in Punit Sharma, as well as the Honorable High Court of Jammu and Kashmir, which very in explicit term discuss all the previous judgments, has come to the conclusion, because I'm for the sake of repetition, I am submitting Jyoti KK's ratio that higher qualification presupposes lower qualification, that remain, my lord. In fact, Zahur Ahmed Rathar also at para 26, the Honorable Apex Court has said that we are in agreement with the law laid by Jyoti KK. My lord, there is one more judgment exactly similar, MVI recruitment by Meghalaya High Court, my lord. I'm just relying on.
So we'll continue after lunch,
Yes, my lord. I'll be obliged.
or you want to do it tomorrow?
Today, my lord.
Tomorrow we'll continue, you will have to respond to one or two things. The qualification prescribed, is it the minimum qualification or it is the maximum and minimum both?
As per rules, lordship, it is the 3-year diploma in automobile.
That's right,
All
but
India
is it the
the-
minimum qualification?
Minimum.
No, not
Huh?
mention anything.
Then why have
about-
you mentioned in the first advertisement?
That's why we have cancelled the advertisement, lordship. After taking views from the judicial department. In fact, lordship, we are not the authority to fix this qualification, it's a central government. As per Motor Vehicle Act 1988, section 213 is very clear. It is the central government, my lord. Lordship,
213 says it's a minimum qualification,
no,
and from
the
that,
central government,
the power has been derived by the state government to frame the rules.
2134, my lord, please have a look. Nothing has been challenged in this petition, my lord. Neither the rules nor
No, I'm not required to challenge.
2134, my lord.
One also will also.
So why
be
I'm
said.
saying that there is a reference today, again, it will
My
be
lord,
part hard.
my lord, tomorrow.
Tomorrow, my
You
lord.
can. So you come, both of you come prepared on,
Lordship.
and his argument that if the higher qualification is in the same line, then it has to
Would-
presuppose.
Punish summary is totally different regarding this present matter, my lord. That my learned senior has relied upon.
My learned friend. Oh. Nonita, Sohor and Punish Sharma. Some different from my understanding.
All right, you argue on that. Take their names, hearing remain in tomorrow as fixed part of matter. So it will be the first item of admission tomorrow.
Lordship.
This will be the first item of admission.
My lord.
Lordship.
PM tomorrow, lordship. 2 PM,
Uh,
some difficult.
Let us see, we'll continue and then.
If any inconvenience, my lord, lordship will accommodate us, but we'll let it remain as a first item, my lord.
I'll conclude it tomorrow, or it will go to May,
Fine.
or it will go to May.
Tomorrow, my lord.